England, 1536. Across the kingdom, the great stone manors and sprawling estates of noble families seemed as permanent as the ancient castles that overlooked them. Fields stretched to the horizon, villages clustered around parish churches, and generations of tenants worked land that had been held by the same aristocratic families for centuries. Yet beneath this appearance of stability lay a legal mystery that few ordinary people understood. Some of England's richest landowners no longer officially owned the lands that made them powerful. On parchment stored in locked chests, estates worth fortunes had quietly been transferred to trusted friends, relatives, or servants. The names written in royal records did not always reveal who truly controlled the property, collected its income, or decided who would inherit it. The legal owner and the real owner had become two different people. The crown watched enormous fortunes slip beyond its reach, while lawyers developed increasingly sophisticated ways to exploit a system that had never been designed for such complexity. At the center of this growing crisis stood King Henry VIII, one of England's most famous monarchs. His reign was marked by ambition, military campaigns, religious upheaval, and extravagant royal spending. Years of war with France and Scotland, the maintenance of magnificent palaces, diplomatic rivalries across Europe, and the enormous costs of governing an expanding kingdom placed relentless pressure on the royal treasury. Henry demanded revenue, yet one of the kingdom's greatest sources of wealth, land, was quietly escaping many of the financial obligations that had traditionally supported the crown. Behind the scenes, another remarkable figure was searching for a solution. Thomas Cromwell, the king's chief minister, possessed an extraordinary legal mind combined with unmatched political skill. Rising from relatively humble beginnings, Cromwell had mastered commerce, law, diplomacy, and government. Unlike many nobles, he understood not only politics, but also the intricate machinery of England's legal system. He recognized that the kingdom faced more than a financial problem. It faced a constitutional challenge. The ancient relationship between land ownership and royal authority was being transformed by legal innovation. Cromwell believed that only Parliament, acting together with the king, could restore clarity to English property law. His answer would become one of the most influential statutes ever enacted by the English Parliament. It would alter the meaning of ownership itself and leave an enduring mark on legal systems across the English-speaking world. But before understanding the revolution that followed, one question must be asked. What if one law could change who truly owned England? To appreciate why the Statute of Uses became necessary, it is essential to understand the world that existed before 1536. Medieval England was built upon land. Wealth was measured primarily in acres rather than coins. Political influence depended on estates. Military service, social status, inheritance, and local government all revolved around ownership of land. Under the feudal system established after the Norman conquest of 1066, every parcel of land was theoretically held from the crown. The king stood at the summit of a vast hierarchy. Great nobles held lands directly. From the monarch, lesser lords held from greater lords, knights held from barons, and tenants farmed the fields beneath them. Every level carried obligations. A landholder might owe military service, financial payments, ceremonial duties, or various feudal incidents whenever property changed hands. These obligations formed an important source of royal income. Whenever an heir inherited land, fees could become payable. If an heir was underage, the king could claim wardship, controlling both the estate and the marriage of the young heir until adulthood. Widows sometimes owed payments, connected with their dower rights. Tenants frequently paid reliefs or other customary charges. Collectively, these rights generated substantial revenue for the crown, while reinforcing the monarch's authority over the kingdom's landed elite. Medieval property law reflected this feudal structure. Ownership was expected to be visible, direct, and publicly recognized. Royal courts preferred certainty. Legal documents identified the person who held title to the land, and responsibility followed that title. Yet, as England's economy expanded during the late Middle Ages, society became increasingly sophisticated. Trade flourished. Families accumulated greater wealth. Noble dynasties sought more flexible methods of managing their estates across multiple generations. Traditional property law often proved too rigid for these changing circumstances. One of the most significant legal developments emerged almost gradually, without Parliament initially recognizing how transformative it would become. This innovation was known simply as a use. At first glance, a use appeared. Straightforward. A landowner conveyed legal title to another trusted individual called a VIII Uses, who officially became the legal owner. However, everyone involved understood that this new legal owner was not expected to enjoy the property personally. Instead, the land would be managed for the benefit of someone else, known as the beneficiary or cestui que jus. The trusted holder possessed legal title on paper, while another person received the rents, profits, and practical control. In modern language, legal ownership and beneficial ownership became separated. This distinction would eventually shape trust law throughout much of the world, but in its earliest form, it developed almost accidentally. Why would anyone willingly surrender legal ownership while continuing to enjoy the land? The answer lay in flexibility and protection. Consider a noble preparing for military service abroad. He might transfer legal ownership of his estate to trusted associates so that his family could continue receiving income if he died or was captured. Religious pilgrims, departing for long journeys, sometimes adopted similar arrangements. Others sought to ensure that younger children, or widows, would receive financial support despite the rigid rules of inheritance governing legal title. In many cases, uses solved practical problems that existing property law handled poorly. Royal common law courts, however, generally recognized only legal ownership. If disputes arose concerning the promises made between the legal owner and the beneficiary, ordinary courts often offered little assistance. Instead, disappointed beneficiaries petitioned the chancellor, one of the king's highest officials, appealing to Barutulu, conscience and fairness rather than strict legal rules. Over time, the Court of Chancery increasingly enforced these moral obligations, compelling legal owners to honor their promises. Thus, alongside the common law, an equitable system quietly emerged. Equity focused less on formal title and more on fairness, intention, and trust. Initially, this complementary jurisdiction seemed harmless. It filled gaps where common law proved inflexible. Yet legal creativity rarely stands still. Lawyers soon recognized that uses could accomplish far more than protecting absent landowners or vulnerable heirs. Because the beneficiary no longer appeared as the legal owner, many feudal obligations attached only to the individual whose name officially held title. If ownership existed only on parchment while control remained elsewhere, the Crown frequently found it difficult to enforce traditional incidents of tenure. Wealthy families began transferring extensive estates into uses, effectively separating practical control from legal responsibility. Imagine a great estate producing abundant harvests, collecting rents from hundreds of tenants, and supporting an influential noble household. Officially, the property might belong to several trusted friends listed in legal documents. In reality, every decision continued to come from the original family. Income flowed exactly where intended. Servants obeyed familiar masters. Tenants paid rents as before. Yet when royal officials examined ownership records, they encountered legal complexity rather than straightforward possession. The distinction between appearance and reality increasingly frustrated administrators responsible for collecting revenues owed to the crown. Tax collectors, royal judges, and government officials found themselves navigating an expanding maze of conveyances, declarations, and private agreements. Each document appeared legally valid, yet collectively they concealed the economic reality of landholding across England. Nobles were not necessarily breaking the law. Instead, they were exploiting opportunities created by the interaction between common law and equity. Lawyers refined increasingly sophisticated techniques, drafting elaborate arrangements that protected family wealth while minimizing feudal burdens. What had begun as a useful legal device gradually evolved into one of the most significant loopholes in English property law. The consequences reached far beyond individual families. Every estate transferred into a use represented potential revenue, slipping beyond traditional royal mechanisms. Wardships, reliefs, and other feudal incidents became more difficult to enforce. In an era when the monarchy depended heavily upon land-based income, this erosion carried profound political implications. Henry VIII inherited not merely a kingdom, but also a legal system, whose ingenuity threatened the financial foundations of royal government itself. As England entered the turbulent 1530s, the conflict between ancient feudal principles and innovative legal practice was approaching a breaking point. Thomas Cromwell understood that solving this problem would require far more than clever litigation. It would demand legislation capable of redefining ownership itself, a reform so ambitious that it would forever alter the relationship between law, land, and power throughout England. Henry V's financial difficulties did not arise from a single source. They were the product of years of ambitious policies that demanded extraordinary sums of money. The king envisioned himself as a Renaissance monarch whose authority rivaled the greatest rulers of Europe. Maintaining that image required magnificent palaces, lavish royal courts, expensive diplomatic missions, and repeated military campaigns. Wars against France promised glory but consumed fortunes in soldiers' wages, weapons, ships, supplies, and fortifications. Even periods of peace brought enormous expenses, as England strengthened its defenses and competed politically with powerful continental kingdoms. Unlike later governments with sophisticated taxation systems, the Tudor monarchy still relied heavily upon traditional sources of revenue. Crown lands produced rents, customs duties, generated income from trade, and feudal incidents continued to provide valuable payments whenever land changed hands. Yet these medieval sources were proving increasingly inadequate for a changing economy. Even worse, from Henry's perspective, one of the largest potential sources of income was steadily being weakened by the widespread use of legal devices that allowed beneficial owners to enjoy land without appearing as its official holders. Every estate hidden behind a use represented money that might otherwise have entered the royal treasury. Thomas Cromwell viewed this not merely as a bookkeeping problem, but as evidence that English law itself required reform. By the 1530s, Cromwell had become Henry's most trusted administrator and one of the most capable government officials England had ever produced. His rise was remarkable. Born far below the ranks of the great aristocracy, he acquired experience as a merchant, lawyer, diplomat, and financial administrator before entering royal service. Unlike many noblemen who inherited influence, Cromwell built his career through intelligence, discipline, and an extraordinary understanding of institutions. He recognized that governments depended upon predictable legal systems just as much as they depended upon armies. A kingdom where ownership could be hidden behind technical legal arrangements was a kingdom whose authority gradually weakened. At precisely the same moment, England was experiencing one of the greatest transformations in its religious history. Henry's break with Rome had reshaped the relationship between church and crown. The dissolution of the monasteries had begun, placing vast ecclesiastical estates under royal control. Monasteries that had accumulated immense wealth over centuries suddenly found their lands surveyed, valued, confiscated, and redistributed. This enormous administrative undertaking revealed both the opportunities and the complications of English property law. Surveyors, commissioners, lawyers, and royal officials examined titles stretching back generations, encountering countless examples of uses and other complex conveyancing arrangements. The government could see firsthand how deeply these legal devices had penetrated English society. Cromwell understood that if England was reorganizing the ownership of monastic property on an unprecedented scale, it was also the ideal moment to reform the broader legal framework governing land itself. Closing the loophole became a national priority because it promised several benefits simultaneously. It would restore feudal revenues, simplify ownership records, strengthen royal authority, and create greater certainty for future property transactions. Nevertheless, achieving these goals would prove politically delicate. England's most influential noble families had benefited from uses for decades. Many members of Parliament belonged to the very class whose legal flexibility Cromwell hoped to restrict. Reform therefore required careful negotiation rather than simple royal command. Cromwell began developing what would become the Statute of Uses. Rather than merely prohibiting uses outright, he pursued a far more elegant legal solution. If equity recognized the beneficiary as the true person enjoying the land, then Parliament could simply declare that legal ownership should automatically follow beneficial ownership. In other words, whenever someone held land for the use of another, the law itself would instantly transfer legal title to the beneficiary without requiring any further ceremony. The separation between legal owner and beneficial owner would disappear. The invisible owner would become the visible owner by operation of law. This concept represented an extraordinary innovation. Instead of abolishing the existing practice through punishment, the statute sought to eliminate the distinction that made the loophole valuable in the first place. Lawyers later described this mechanism as executing the use. The moment a valid use existed, legal title would immediately vest in the person entitled to enjoy the property. No intermediary could stand between beneficial ownership and legal ownership because the law would merge them automatically. Such an approach reflected Cromwell's practical understanding of legislation. Rather than fighting every individual arrangement through endless litigation, Parliament could change the underlying legal principle itself. Political negotiations, nevertheless, remained intense. Some landowners feared losing carefully planned inheritance arrangements that protected younger children or surviving spouses. Others worried that restoring strict feudal incidents would increase financial burdens upon noble families already adapting to rapid political change. Lawyers debated technical questions concerning conveyancing, while judges considered how existing precedents might interact with the proposed legislation. Supporters argued that clarity, fairness, and efficient government required reform. Opponents warned that disturbing established property arrangements might create uncertainty throughout the kingdom. Henry VIII, however, required little persuasion regarding the financial advantages. Restoring revenues aligned perfectly with his broader efforts to strengthen royal government following the break with Rome. Parliament likewise recognized that England's legal system needed modernization. Although individual members possessed differing motivations, many accepted Cromwell's argument that the separation between legal and beneficial ownership had expanded beyond its original purposes. What had once solved genuine practical difficulties had evolved into an increasingly sophisticated means of avoiding obligations that Parliament had never intended to remove. After considerable debate, the proposal gained sufficient political support. In 1536, the Statute of Uses became law. Few acts of Parliament have altered legal doctrine with such immediate effect. Overnight, countless property arrangements across England were reinterpreted according to the statute's new principles. Wherever one person formerly held land merely for another's benefit, the law itself now transferred legal ownership directly to the beneficiary. The trusted intermediary effectively vanished from the chain of title. Estates that had appeared legally fragmented suddenly became unified once more. For many landowners, this represented an astonishing legal transformation. Documents that had once carefully distinguished between the nominal owner and the real beneficiary now produced entirely different consequences. Beneficial owners became legal owners automatically. Since they now officially held the land, the traditional feudal incidents attached to them once again. Royal officials could identify ownership more easily. Wardships, reliefs, and other obligations became enforceable against those who genuinely controlled the estates. The Crown regained access to revenues that had increasingly escaped collection. Property transfers also became more transparent. Purchasers examining title could identify actual ownership without navigating hidden equitable arrangements designed to conceal beneficial interests. Judges applying the statute possessed a clearer framework for determining who legally owned particular lands. Government administrators found land records more closely aligned with economic reality. From Cromwell's perspective, the statute achieved precisely what effective legislation should accomplish. It simplified complexity while strengthening public administration. Yet, legal reform rarely produces only winners. Many noble families immediately recognized that valuable estate planning techniques had disappeared. Carefully constructed arrangements protecting family wealth no longer functioned as before. Some inheritance strategies collapsed. Certain tax advantages vanished. Individuals who had relied upon uses to separate control from ownership discovered that Parliament had erased the distinction itself. Unsurprisingly, dissatisfaction spread among those whose legal flexibility had been dramatically reduced. The greatest beneficiary was unquestionably the Crown. Henry VIII gained stronger control over the legal framework governing land, improved opportunities to collect traditional revenues, and greater visibility regarding ownership throughout the kingdom. Royal government became more effective because property records more accurately reflected actual control. Government officials responsible for administration likewise benefited from increased certainty and reduced legal ambiguity. Courts spent less time untangling deliberately complicated ownership structures designed primarily to exploit technical distinctions. Yet, if Cromwell believed the statute would permanently eliminate sophisticated property planning, he underestimated the creativity of English lawyers. Within remarkably few years, legal professionals began searching for alternative methods capable of preserving many of the practical advantages previously achieved through uses. Instead of accepting Parliament's reform as the final word, they studied the precise language of the statute, identified its limitations, and experimented with new conveyancing techniques that technically complied with the legislation while recreating similar economic results. The contest between lawmakers seeking clarity and lawyers pursuing flexibility was far from over. In many respects, the Statute of Uses did not end the history of trusts. It marked the beginning of a new chapter in which English law would continue evolving through judicial interpretation, equitable principles, and ingenious legal innovation. As one loophole closed, another generation of lawyers prepared to discover what possibilities still remained hidden within the language of the law. The years following the Statute of Uses demonstrated one of the enduring truths of legal history. Legislation rarely marks the end of a legal problem. More often, it begins a new conversation between lawmakers, judges, and lawyers. The Statute of Uses succeeded in eliminating many traditional uses by automatically transferring legal title to the beneficial owner, but it did not eliminate the human desire to manage property with flexibility. Families still wanted to protect widows, provide for younger children, preserve estates across generations, and separate management from enjoyment. Merchants required increasingly sophisticated arrangements as commerce expanded. Charitable institutions needed dependable methods of holding property for public purposes. The practical needs that had originally inspired uses had not disappeared, simply because Parliament had altered the law. English lawyers responded with remarkable creativity. They examined every word of the statute, searching for situations in which it did not apply. New forms of conveyancing emerged, carefully structured so that legal ownership and beneficial enjoyment could once again be separated, without triggering the automatic transfer required by the Act. Some arrangements involved multiple layers of ownership. Others relied upon technical distinctions that Parliament had not anticipated. Judges, meanwhile, continued to hear disputes in which strict legal title alone failed to produce fair outcomes. Increasingly, litigants turned once again to the Court of Chancery, asking the Chancellor to enforce obligations based not only upon legal ownership, but also upon conscience, fairness, and intention. This gradual development became one of the defining features of English law. Rather than abolishing equitable principles, the Statute of Uses unintentionally encouraged them to evolve in new directions. The Court of Chancery continued to recognize situations in which one person ought, in fairness, to manage property for another. Over time, these equitable interests developed into what modern lawyers recognize as trusts. Unlike the medieval use, the trust became a more sophisticated legal institution, supported by centuries of judicial decisions. Trustees acquired legal ownership accompanied by enforceable duties. Beneficiaries received equitable rights protected by courts. Rather than existing as a loophole operating outside the legal system, trusts gradually became an accepted and highly developed part of that system. Ironically, one of Parliament's greatest attempts to eliminate divided ownership ultimately helped shape the modern law governing divided ownership. The relationship between common law and equity also became more clearly defined. Common law courts focused upon legal title and formal rules, while the Court of Chancery addressed fairness, fiduciary obligations, and equitable remedies. Although tensions sometimes arose between these jurisdictions, together they produced a legal system capable of balancing certainty with flexibility. Property owners gained clearer rules governing ownership, while still possessing mechanisms to achieve legitimate family and commercial objectives. The Statute of Uses, therefore, did not destroy English property law. It accelerated its evolution. The influence of these developments extended far beyond England. During the 17th and 18th centuries, English settlers carried their legal traditions across the Atlantic Ocean as colonies expanded in North America. Along with the English language, parliamentary institutions, and common law, they brought principles governing land ownership, inheritance, conveyancing, and trusts. Colonial courts in places such as Virginia and Massachusetts relied heavily upon English legal precedents. Lawyers trained in English legal doctrine advised colonial governments, drafted property transactions, and resolved disputes according to principles that had evolved over centuries, including those shaped by the Statute of Uses and the subsequent growth of equity. Land occupied an especially important position in colonial America. Vast territories required organized systems of ownership if settlements were to expand. Families purchased farms, established plantations, transferred estates to future generations, and created charitable institutions that required dependable legal structures. English trust principles proved adaptable to these new circumstances. Even after the American Revolution severed political ties with Britain, many foundational legal doctrines remained. Newly independent states generally retained large portions of the English common law because it provided stability, predictability, and an established body of judicial reasoning. As the United States developed its own legal identity, courts continued refining trust law, while preserving many concepts inherited from England. Today, although American trust law differs in many respects from its English ancestor, historians can trace important elements of its development back through centuries of legal evolution, beginning long before independence. The same pattern appeared throughout much of the English-speaking world. Canada inherited English common law traditions while adapting them to Canadian institutions. Australia incorporated trust principles into its rapidly developing legal system during the 19th century. Numerous other common law jurisdictions likewise built upon doctrines, whose origins stretched back to Tudor England. Modern estate planning, fiduciary duties, charitable trusts, pension funds, investment management, and countless commercial arrangements all reflect legal concepts shaped by centuries of development following the Statute of Uses. Historians continue to debate precisely how the statute should be remembered. One influential interpretation emphasizes political power. From this perspective, the legislation represented another step in Henry VIII's broader effort to strengthen royal authority during a period of extraordinary constitutional and religious transformation. By restoring feudal revenues and increasing transparency in land ownership, the Crown reinforced its financial and administrative control over England. Supporters of this interpretation view the statute primarily as an instrument of centralized government. Another school of thought highlights modernization rather than royal power. These historians argue that the medieval system had become increasingly unsuited to England's evolving economy. Uses reflected genuine social and commercial needs that traditional property law handled imperfectly. Even if the statute failed to eliminate flexible ownership arrangements permanently, it forced English law to confront changing economic realities. According to this interpretation, the legislation accelerated the transition from a rigid feudal framework toward a more sophisticated legal system capable of supporting expanding commerce, increasingly complex family arrangements, and long-term economic growth. A third perspective focuses upon the lawyers themselves. Rather than viewing Parliament as the ultimate victor, these scholars argue that legal professionals effectively outmaneuvered the legislation. By identifying technical limitations within the statute and developing new forms of trusts, they preserved much of the flexibility that landowners desired. In this view, the Statute of Uses became less a final solution than another stage in an ongoing dialogue between legislation and legal innovation. Parliament changed the rules, but lawyers changed the game. Each of these interpretations contains elements of truth. The statute undoubtedly strengthened royal administration. It also encouraged the modernization of English property law. At the same time, it failed to eliminate divided ownership because equity adapted with remarkable resilience. Legal history rarely presents simple victories or complete defeats. Instead, it reveals continuous adaptation as institutions respond to changing economic, political, and social circumstances. Nearly 5 centuries after 1536, the legacy of the Statute of Uses remains visible in ways that most people never notice. Every time a family establishes a trust to manage wealth for future generations, every time an estate plan seeks to protect beneficiaries while complying with legal requirements, every time courts distinguish between legal ownership and equitable interests, they operate within a tradition profoundly influenced by the debates that unfolded during Henry VIII's reign. Modern real estate transactions depend upon principles of title, registration, and ownership that evolved through centuries of legal refinement. Trustees managing charitable foundations, pension funds, educational endowments, and investment portfolios continue to perform fiduciary duties rooted in equitable doctrines that emerged after Parliament attempted to eliminate uses. Lawyers advising clients in Britain, the United States, Canada, Australia, and other common law jurisdictions still rely upon concepts whose historical foundations can be traced to Tudor reforms and the legal innovations they inspired. The Statute of Uses therefore occupies a unique place in legal history. It was designed to solve a practical financial problem confronting a Tudor king, yet its consequences extended far beyond royal revenue. It reshaped the relationship between law and equity, transformed property ownership, encouraged the evolution of modern trust law, and influenced legal systems across continents. Henry VIII sought greater control over his kingdom's wealth. Thomas Cromwell sought a clearer and more effective legal framework. Neither could have fully anticipated how their legislation would continue shaping legal thought centuries later. Nearly 500 years ago, one Act of Parliament transformed the meaning of ownership. The Statute of Uses reshaped England's legal system, influenced the evolution of trust law, and left a legacy that continues to affect property rights across the English-speaking world. Its impact reminds us that a single legal reform can echo through history for generations, proving that laws are not merely words written on parchment, but living institutions capable of redefining power, wealth, and justice long after the lawmakers themselves have passed into history.